I'll call case number 116629, State of Kansas versus Charity Downing.
May it please the court, Andrew Davidson for the state of Kansas. I would ask for 3 minutes of rebuttal.
3 minutes is granted.
This case began as a burglary case. Ms. Downing was proceeded to trial, was found guilty of burglary to a residence or to a dwelling by a jury. The case was appealed by the defendant, challenged on grounds of sufficiency of the evidence at the Court of Appeals. The Court of Appeals overturned the verdict, and the state petitions for review. The questions in this case are, the first question is, did the house that was burglarized in this case meet the statutory description of a dwelling? In this case, the second issue is, if this court finds that the Court of Appeals should be affirmed and that the state didn't meet its burden on the dwelling, that she should be sentenced under the lesser included statute of burglary to a non-dwelling. The state would argue that the home meets a statutory designation of a dwelling. In this case, it was a house that had belonged to the victim in this case for many years and had been in his family, and it was a farmstead. He had kept numerous household items inside, such as sofas and freezers and things of that nature, but no one had occupied the dwelling for a few years. During testimony, he indicated that he would like someone to be able to stay in that residence. He would like to be able to rent it out, but because of the items inside, he thought it might be dangerous for his property to turn up missing. He comes across his farmstead and finds that the door had been pushed in and that someone had been inside and removed items from that residence. The state would argue that this was a house for the purposes of the statute because of its nature, the fact that it was a residence prior. It would appear to be a residence from anyone outside of this house, and when they broke in, it would look like a residence to them. The Court of Appeals found that it didn't meet that standard, but the state would point out that a dwelling is one that can be used or is intended to be used as a dwelling based on what the individual in this case had inside the house and what his intentions were when he was testifying. He would like it to be used as a dwelling. That is what...
Does a dwelling ever cease to be a dwelling? Once it's determined that it was habitable at one point in time and now it's no longer, maybe I'll do it in the future. Is there any time that it ceases to become a dwelling and just a structure?
It's a difficult question because I think you have to look at each case on a case-by-case. Let's say somebody turns a house into a law office and doesn't live there during the evenings, but it's a house from the exterior. Maybe that one has become a non-dwelling, but a house that's always been a house that's not marked as a...
once a dwelling, always a dwelling. Is that your position?
Yes, I think that this house, I think part of the reason why the statute designates the separate person designation from a non-person is because of the risk assumed by somebody who's burglarizing inside that residence. We protect a person's house more than we protect because of the vulnerabilities inside that someone would feel if someone came into that place.
Even though those vulnerabilities in this case didn't exist and haven't existed for years.
But it would look to Charity Downing that this was a farmhouse and it was occupied, and she went in to go clean it out.
I can't reconcile that position, though, with subsection A2, which tells us, what's not a dwelling. And it includes things like the mobile, manufactured housing and mobile homes and that kind of thing. So outward appearance doesn't seem to be a deciding factor, right?
No, it does. It's what it's intended to be used as, I think, based on the case law cited in our brief.
So if it's what's intended to be used and the owner says, A, I'm not there, B, it'd be nice if somebody was there, but C, I have no plans for putting anybody there, haven't you just talked yourself out of at the application of subsection A1 and should have been in A2?
I don't know if the victim in this case had talked himself out of using that as a residence in the future. It's just at that moment.
He said he had no, we can't change his testimony. He said that, I don't have any plans to do this.
But he said he would like to use it as a rental.
Okay.
So, anyway.
So if the purpose of having, the dwelling distinction is one of protection, or a prevention of the increased danger that somebody's going to be there, then how is that purpose fulfilled if it's just, well, I have a dream that someday someone will move into my house, but I have no current plans to do that. In fact, I've got it full of junk where nobody would want to be there anyway. I mean, that's what we've got here.
Yes, I understand the distinctions that were drawn upon by the Court of Appeals, and that's up for this court to decide ultimately. The second issue in this case is, does this warrant just complete and total reversal and vacation of the conviction, or can this court look at the lesser included of burglary to a non-dwelling and uphold a conviction for that charge?
So let's assume you want to move to your alternative argument. You didn't make that argument to the Court of Appeals, did you?
It wasn't in the brief, no. But the Court of Appeals decision that came out, because of the complete vacation of the sentence and the conviction, that's what we petitioned for review on, because we believe that the court has the authority to uphold the conviction of the lesser included under Kansas law.
And what authority do you cite as support for A2 being a lesser included offense of A1?
The elements are almost exactly the same. The only difference is the distinction between the dwelling and the non-dwelling, and the fact that the defendant's brief only challenged the sufficiency of the evidence on whether or not it was a dwelling, not whether or not that the burglary happened at all, and that it's the facts support burglary under the alternative theory that this was a non-dwelling, and that the lesser included case could be remanded for resentence based on State v. Wilt, State v. Dawes, and State v. Montgomery. And so we would argue that the court could uphold the conviction for burglary to a non-dwelling, and that it would be required to be resentenced under that statute, under a non-person.
I didn't quite understand your answer to Justice Biles' question about preservation. Because this issue was not raised at the Court of Appeals, how is it properly before us? Because
the opinion, instead of holding that the defendant, because the ruling was that the sentence is vacated, we have a remedy to,
Are you saying that you're allowed to bring it for the first time on appeal to this court because you
because
were
they made-
surprised by, I mean, couldn't the state have made this argument to the Court of Appeals, I guess is what I'm getting at. You didn't have to have the Court of Appeals ruling to put you on notice that this was a potential issue.
No, but because of the Court of Appeals ruling, we appealed that for that error.
You're saying that the remedy, you're free to bring up an argument on the remedy the court provides, even though it wasn't something discussed before the Court of Appeals. Is that right?
Yes,
Okay.
thank you. Any other questions?
Thank you. Ms. Davis?
Michelle Davis, I'm appearing on behalf of the appellant, Charity Downing. I think I kind of agree that the state sort of took an all or nothing position here with this. They didn't charge any alternative or anything like that, so they just went after this conviction and really just didn't put any other offense into play.
Well, it's really not a lesser included offense, it's an alternative charge, isn't
It
it?
would be an alternative charge, that's our position.
So any case law we have on lesser included offense really doesn't apply to this scenario anyway.
That's correct. I don't think the state's established that it's our position it isn't, and the state has
Well, it's
never
not a
put anything-
lesser included offense. You wouldn't instruct on it that way.
I'm not gonna argue with you on that. We're in agreement. And I think this idea of habitation, a dwelling, I mean, a tent and a vehicle can be a dwelling under the statute because it's basically an enclosed space where somebody's, I think what the word they use, used or intended for human habitation. So most people don't look at a vehicle and think they're burglarizing a dwelling. But if a person's living out of their vehicle, then the state can prosecute that as burglary of a dwelling. So it's really not, the type of structure that you're looking at. It's more the intended use is the way that the legislature defines. So based on that, I think the Court of Appeals was clearly correct in its ruling in this case.
And do
And
we
you-
just surmise, or do we know that it's because there's a higher risk if the dwelling's being invaded, that there might be a human inside who could be harmed by the burglar?
Yeah, I think it's more the violation. We think of our home as a safe space.
So what does it take to show a dwelling? I mean, here the victim testified, I was hoping to have people live in this house. That's what it was used to prior to when people weren't living there. Why isn't that enough to determine it's intended for human habitation?
Yeah, I think that the Court of Appeals was correct in relying on the plain statutory language, and I think it is fairly broad, used or intended for use. I just don't think the state's evidence in this case matched up because the state's witness testified that he was using the space for storage.
And so what is the time frame?
Right.
Because it is used or intended
Intended
to
for
use, so
use.
it's looking at present and future. So if the evidence was current use is storage,
Yes.
then if there is a statement that I intend to rent it, why is that not enough to meet that future portion of the definition?
Well, I think it has to be something that intent being some sort of current intent to use it for that purpose, not just down the road, I may do this with this piece of property.
So it has
So-
to be pretty close in the future.
Right, it has to be a current sort of intent of what I'm gonna do with this property. My intent is to use it in this way now. So for example, if he was fixing it up, because he was restoring it, because we're gonna use it for human habitation, this is our current intent.
And where
Then-
do we get that from the plain language of the statute?
Well, there's a few cases I think that are cited in my brief where they talk about that, where the person was fixing up the property.
So it is the so we do look to the statute, not, rather than just from the words used in we look to the case law rather than the words used in the statute.
There's a couple of Court of Appeals cases on this where, nobody was actually living in the property, but they were fixing it up, and they went from there, but we don't even get anything close to that here. So I think the idea would be if you were fixing it up as a human habitation and somebody comes into it, that's kind of they're coming into your home because you're intending to use it as a home, or you've done some sort of action towards that where this is some kind of more protected property, I think, would more be the standard than just, one day I could use this property this way. Then you're not violating the sanctity of somebody's home our intended living space, I think is more the thinking there. I think that's what the legislature is trying to protect here. So that concludes my comments unless there are questions.
Any other questions? Thank you.
Thank you.
I would like to clarify my answer to the earlier question, that the reason why we believe that this court would have jurisdiction is that this is a question of law, where the review would be unlimited. And that's all I have for my rebuttal in this case.
Anything else from anyone? All right, thank you. The court will take this matter under advisement.
Thank you.